So I'm back and I'm here to talk a little bit about something that happened over the cruise, the Adelson trial, and to give some other opinions and just kind of set the record straight on some things. Here's what we're talking about today. Now, before I get started, I have to tell you that I have a cold. And that's because there just seem to be this large group of people who cannot help but be absolute germ factories. And they walk around and they sneeze openly and they cough without covering their cough. And unfortunately, that aerosolizes droplets, and the droplets carry the infection. And now my head and nose feel like someone has injected concrete into them, and it's made life rather unbearable, actually. But I'm here, and I'm here to talk about some things that are important to me. So, longtime subscribers already know much of what I have to say here, but I feel like I have to say it today. First of all, opinions are like noses. Now, I know there are a lot of people who say that opinions are like another part of the anatomy, but the nose is actually better, uh, probably a better metaphor, simply because it doesn't require you to describe anatomic terms in ugly language. When I express an opinion, I don't ever expect it to reach the lawyers trying the case. The only time that this happened that I know of was in the Karen Reed case, and I can't discuss that issue. I'm not trying to help one side or the other. I guess except in the Karen Reed case, because I was trying to help because that case was such an injustice. But most of the time, all I am doing is giving you the inside baseball information on what's going on, what should have been done, in my opinion, and apparently was not done, or what was done and apparently should not have been done. Again, these are my opinions. If you take one of my opinions and you march down to Starbucks, my opinions and your $10 will get you a cup of coffee that can sometimes be drinkable. In the Adelson trial, I had a comment from someone who suggested I was trying to school the defense attorneys on objections. Now, that's nonsense. If two attorneys trying a case involving a life without parole sentence are taking direction from a random YouTube lawyer who isn't even admitted in their state, that would be the textbook definition of ineffective assistance of counsel. Now, I have opinions on Adelson. I saw a lot of the videos of the trial. I did not see much of the opening statements. We had bad weather that day, and the internet just wasn't clearing. What little bit I saw, I thought the defense attorneys did an okay part of the part that I saw. They were actually talking cogently, and I thought trying to do a good job of setting up an alternate theory. I don't think it worked, but I do think that they were trying. And I made that comment, and people jumped all over me saying I didn't know what I was talking about. Well, later on, as I watched additional work that they did, it was pretty clear that they were in over their head, and that I guess I could understand how somebody could think I was trying to school them, but that's not my job. My job is to talk about this so that you guys understand it. Now, it was clear to me that people who came to listen to the video and were not subscribers, in other words, they hadn't been here, they hadn't seen how I handle issues, they hadn't listened to me discuss a case before. They were fans of the prosecution in that case, and that happens in every trial. Some people are going to be fans of the prosecution, some people are going to be fans of the defense. How do I know that? Because there are people who hold the honest and sincere belief that Karen Reed was guilty. And I'm sure that they hold that honestly. I don't know how they hold it honestly, given what I saw in that trial, but everybody sees something different, and I respect their opinion. There are also some people who hold the honest and sincere belief that Brian Koberger was innocent and was therefore framed. I don't know how those people derived their views, but again, they hold those views honestly and sincerely, and they are entitled to them. Now, people routinely cheerlead for their favorite litigant. when I say something that goes against what they believe or wish or hope. A lot of times they get upset and leave silly comments. Most of the time, I don't respond. But the idea that I was trying to help out Donna Adelson's lawyers was just almost too much to let go by. So I wanted to put this in a video so that people understood. I'm not cheerleading for the defense any more than I would be cheerleading for the prosecution when I pointed out that these guys are missing every available objection that they can make. Rather than go through all of the Adelson video, which I could download from YouTube and comment on, I'm going to take one issue of the videos that I saw toward the end of the Adelson trial on one of the C days when I could actually get the video, and I'm going to talk about an issue. This is going to be my one and likely only video on Adelson because, one, I think they got the right verdict, and two, people who believe that Wendy is guilty are not going to stop clamoring for her to be tried. So it seems like there are always people who make videos about what's going to happen next, who's going to do what. Are they going to indict? Are they not going to indict? What are they going to indict on? All of those things. I don't want to do that. I don't want to essentially speculate on what the state is going to try to do or what Wendy's going to try to do. I don't think she'd fit in very well in Vietnam. I'm just saying. But I'm not going to have any more comments. As to Donna, I believe that justice was likely done. Keep in mind that every criminal case that ends in a conviction, particularly one where it involves life without parole, is going to be appealed. And sometimes appeals, which do not decide guilt or innocence, but which only decide trial court error, sometimes they're effective. The issue which I want to talk about was the detective's discussion toward the end of the trial of the phone calls on the morning of the murder. Now, cops always like to talk about the links between members of a conspiracy, how they're holding hands and getting this all done. When there are emails and things of that nature, and you can see the content of the communications, and you can hold up and point on there and say, this is what happened. Well, when those are there, things of that nature, you can see the content, and it's easy to understand what's going on. Nobody has to speculate about what killed the SOB means. It's pretty clear when that's in an email. So to put this in context, I'm going to go back and talk about a case that I was involved in a few years ago briefly, where a teacher was charged with taking indecent liberties with a student. Now, I'm not routinely a criminal defense lawyer, although all lawyers should be able to provide immediate help to somebody who is facing charges until they can get them in the hands of a competent criminal defense lawyer, and that's what I did. So this was a male teacher and a female student. The teacher was also a coach. The student that wound up getting him charged was on the softball team that he coached. And the student that did this basically told her boyfriend that she had slept with this coach to make him jealous. Well, it worked. It worked so well that he went to the cops and demanded that the teacher be prosecuted. So enter the cops. The cops come and talk to the girl in front of her boyfriend. She doesn't deny that she said that, and they immediately take that to assume that this indeed did happen. Well, I'm pretty sure they got a printout of all of the text messages between the teacher and the student because this happened at or about the time when these messages were exchanged. But they didn't ever try to introduce the text of the text messages. Instead, what they tried to do was they tried to introduce just the raw number. Now, I'm sure they had the content of the communications, as sure as I can be, but because they didn't enter them into evidence, I have no idea what they said, but I have a strong belief that I know what they said. Over strong defense objections, they insisted in entering only the raw number of messages, and there were over 1,000 messages between the two. The defense objected because, stripped of their contents, the number of messages could allow a jury to speculate on the content when the state had the ability to get the content but let that information pass off the server before it could be downloaded by the defense. Yes, it was a Brady violation. No, the court still allowed the evidence in. Now, any of you who may have taken college algebra in high school know that it's a tough subject. And this gal was not the brightest bulb in the chandelier. So, all of the math students that were effectively a student of this teacher had his cell phone number. And if they had a question about one of their assigned homework problems, they could shoot him a text and say, on page 4, question 6, and they could ask the question, should I cross multiply and divide or do something else? And the teacher would text back. And then this girl would ask a follow up question, and then he'd text back. And of course, when you're talking about math, a lot of times you can't put everything down the way you would scribble it down on a piece of paper. So, what the teacher did was he would send 3 or 4 texts to explain the advice that he had given. So, there would be a lot of text messages in that situation, particularly when she was in that class for over a year. Now, she might tie him up for 45 minutes at a time that way after school, and stripped of the contents of the emails, it could be looked on as bad behavior. But in order to do that, you have to speculate about the contents of those emails. Now, the young lady played her role to the hilt. She came to trial and she took delight in saying she'd had consensual relations with this teacher, but she had to admit on cross examination that the majority of those text messages were about math. Now, I have often said that jurors very rarely make mistakes. They do sometimes, but very rarely do they make mistakes. And they saw right through this young lady. Cross examination of her was brutal, but it was necessary. Due to an excellent trial attorney, not me, the teacher was acquitted. But because they brought the licensure action against him while the criminal case was pending, his lawyer told him he absolutely could not testify in the proceeding to take away his teaching certificate, because if he did, it would be used against him and he would have waived his Fifth Amendment right. Probably they would have he would have gone into trial that way. So justice in one sense was done. He was acquitted, but not in another, because he did wind up losing his teaching certificate. So what the cops are doing in the Adelson case, where they did not have the contents of the phone calls on the day of the murder, the calls on the day of the murder were not recorded. They didn't have these phones tapped. What they're asking is for the jury to speculate on what they are talking about. They're saying, look at all these phone calls. They must mean something. Well, yeah, they could mean, what are you wearing to work today? How's the weather where you are? I don't know what they meant. Nobody knows what they meant, because it's been like 8 or 9 years, maybe even longer than that, since all these things took place, and they don't have the contents. They only have the raw number of calls. These are family members. They call each other all the time. The state was essentially inviting rampant speculation about the contents of those calls, suggesting they must have been about the murder, because they had no way to prove up the contents of the communications, except those between Charlie and Katie, which Katie talked about. The calls between Charlie and Donna and Charlie and Wendy were offered to show the involvement in a conspiracy. But do they show that? I don't think so. And I think since the state has the burden of proof to show it beyond a reasonable doubt, how can you ask a jury to speculate that the number of phone calls and the time of the phone calls mean anything, stripped of what those calls were talking about? So I think an objection to calls for speculation on the part of the jury should have kept that away from the jury. I don't know whether the defense ever made that objection. I didn't hear them make that objection. They may have made it pre-trial and had it be overruled in a motion for limine. I haven't looked. But if indeed that was allowed in, that was speculation, and that's not evidence. Now, these lawyers who were lax with their objections, but who gave a workmanlike closing that I think fell flat because it couldn't tie up all the loose ends, they lost that case. Did this issue, the speculation about the phone calls, make a difference? Who can say? Should the appellate lawyers look at that issue? Absolutely. So, for those of you who want to know, I had a great trip and I thank you for the time that I took off. I'll be doing a stream dedicated to talking about all the things that happened on that trip here in a few days when I get all the photos and videos downloaded and organized. But today, I want to leave you with these images of the Northern Lights shot near Adelson, Norway on 9/3/25. Thanks for watching. I appreciate you being here today. If you have the opportunity today, try to do one kind thing to help somebody else. Any kind thing will do. Buy somebody a Coke, get them a cup of coffee, anything that makes their day better. That would be a way to help make the world a better place. Because after all, isn't that what we're all after? Now, YouTube has a few things that they think you might be interested in, and they're going to be showing you that right up there.